before you tell me who it is for. Okay, I'm not a fan of having receiverships on a regular collection agency debt because um, it gives you so much power. I would rather have that you get your judgment and then see if a receivership is proper. But tell me about the debt. Tell me about the creditor, and explain to me.
So this one, it may help you to know this is not a debt buyer. This
Okay.
was the original creditor. So, and Daimler Truck, what they do is they lease trucks. So, it's Daimler, the manufacturing company, but they have a truck leasing business. They leased a truck to a gentleman, Joseph Amore. He didn't make the payments, and they obtained a judgment on Exhibit A to our motion. There, we've got the original judgment, which was granted back on May 15th of 2024 in this court with for the amount of $37,152.94 plus attorney's fees. So that judgment has been rendered, and what has happened is we have not been able to collect it.
Okay.
So
Was it a default judgment?
so originally, let's see, it didn't, I don't think, say the original case. Let me see. Got the judgment right here. Yes, it was a default.
Okay.
So original default have not been able to have non-exempt assets that's attached to the application here. Exhibit B shows a Wells Fargo bank account. And so that's basically, we're looking to having a receiver appointed to see if we can collect on this.
Yeah, but okay. If I may, Mr. Naylor, where are you at?
I'm in Houston.
Okay.
The firm is in Austin.
No, that's fine. I had receiverships being solicited out of a firm in Ohio,
Oh,
and Toyota Credit Corporation or whatever was really big on them. And then the word got around. I mean, I've talked to other judges around the state on this. I just don't think that. What have you done to try and collect the 37,000? I mean, you said you're looking for exempt assets. Have you brought them in to depose him on where assets are located?
so I don't have any evidence that that happened. This obviously was originally a default. I don't know if it might have been even a subservice thing. I don't have that. The court would have that. But I'm assuming that they didn't think that would be fruitful because, on a default, people have ignored the court essentially already. So,
I used to do collections. Okay,
okay.
right out of law school, I'm very familiar with all that, and and I know the frustration of dealing with a deadbeat or someone. I mean, obviously, the credit was extended. That amount, they obviously had access to Mr. Moore. If it was a mistake because of the kind of person he is, that's on them that they extended credit. But I'm not ready to go on a receivership in this type of case until you tell me we've already done this, we've already done that, we've already brought them in. Uh, I'm sorry. The next step that I can compel his appearance on is you bring him in, and if, when he doesn't come in, I issue an attachment. I bring him in and I tell him you got to answer these questions, and that's a more direct order from the court. But a receivership, I haven't seen your receivership provisions, but basically you're allowed to control the ones that I've seen. You're allowed to control his bank account and do all sorts of stuff. And here's a guy who, yes, he didn't even show up, but all of a sudden now it's going to be like, oh my gosh, I think it's too much of a shock to do that to a debtor, and to give so much control to a third party to be able to go after him without proper supervision of the court, in the sense of I'm granting you the ability to be able to do that, but there is no mechanism to come in for him to even say, judge, they're abusing this and they're abusing that. So I would rather that you go with less drastic means before I grant a receivership. I do believe in receiverships. I think they hold a proper place, but that's kind of my I'll be happy to look at it at
Okay.
what you want.
Well, Your Honor, maybe it would help a little bit that I tell you This case is brought by Barnett Garcia and Matt Garcia, who's the partner in that firm. He wrote the Texas Collection Manual. So we're not dealing with some out-of-state debt collector or anything. This is, local guys that know what they're talking about. And we don't just willy-nilly file these. Every once in a while they do when they have somebody that is completely unresponsive. So that may be helpful. Now, we filed an order in the case here for the appointment of a receiver. I think you're welcome to mark through that, or if you would like to have us skinny that down and just say we're only limited to trying to find a bank account or something like that, that would be okay. Because I agree, some of these powers are pretty broad, opening their mail and stuff like that. So,
Well, even the bank account. Okay, listen, I have all due respect to the Garcias, and that's great that they've drafted that. And receivership is a tool that the state and the law provides. And I'm just saying that as a judge in this particular case, I'm very hesitant to grant receiverships like that. That they can even go search, go to every single bank in town and get that kind of information until he has some kind of notice that I might give that power, and that's why I'm saying that I prefer a less drastic alternative to begin with. And I actually even consider that partly on a due process issue. That instead of just granting this receivership, yes, you can have it, and the law allows it. I want an escalation of remedies that doesn't automatically give you a receivership over someone who didn't even show up.
okay.
Now, you file that motion and all, uh, Robert, make sure I have that and the order. I'm probably going to deny it. I'm telling you right now why. And these proceedings are open on YouTube. Okay, I'm accountable for what I do,
Yeah.
and I'm familiar with the community that I work in, and I'm comfortable explaining to you. I guess you could file a mandamus, but I don't
No,
know.
no, that's not
No,
happening.
no,
So,
I know, Mr. Naylor, but it would be interesting if
yeah.
somebody has filed a mandamus where something got published where it said, "Oh, a judge must grant receiverships."
No, I actually,
Whenever,
I think it's totally up. I think it's your discretion, actually,
yeah.
and the procedure is your discretion, and we're glad to try to do that. And I'm thinking what I'm hearing, maybe this isn't quite right, is if we do some discovery, send out some discovery, and try to get some kind of a response, you might entertain this, or no,
Well,
even
I'm not. I don't give. What is it?
you're not going
Opinions
to tell
on
me
what I
ahead
would
of
do.
time.
I'm not going to commit myself to that. But all
Yeah.
I'm going to say is this: I hardly ever see collection cases where they're doing that.
Okay.
Where they're going out and setting something up. But if you serve him for some kind of a discovery deposition or whatever that's part of the collection process, and he doesn't show up, and you come in for sanctions, I'll have him attached. I'll bring him in.
Okay.
But it's going to be tough if was this was the service on this Rule 106?
I don't know. I don't
Okay,
have.
but see, that's a consideration also. It's sort of
Yeah.
like the guy got sued. Okay, legally he got service. I don't need a videotape that he got it. He probably did, but I'm
Yeah.
just saying somebody totally detached from the system, and then all of a sudden, boom. Uh, if you wanna set the what do they call interrogatories? What kind of interrogatories on the collection uh, procedure?
Well, it's just regular interrogatories and requests for document production.
No, I know, but there's a term for it in a collection setting. It's a post judgment. Um, well, I can't remember how they refer to that term because I've been out of law school such a long time, and that was my first job out of law school 35 years ago.
Okay.
Um, but if you jump through that hoop, and it's not a hoop, if you provide that kind of notice to him, and then
Oh,
you can
okay.
legally attempt to get his bank account number if he wants to give it to you or not or whatever, and then you come to court, I will tell him what he has to do.
Okay.
But
Okay.
sometimes some of these debtors, sometimes they're deadbeats. They've been deadbeats all their life. I just can't believe that your client extended credit in that amount to this person without checking in on his background. you know, and then now they're out the 35,000, which is a substantial amount to be out of. How much were the attorney's fees in that case? On the
The original attorney's fees were that in the
that I gave.
in the
Right.
judgment, yeah, let's see, was I think it was $1,200.
So that was reasonable. I mean, in other words, your client is pretty reasonable in trying to collect this, and collections are part of their methodology of trying to get their money back and stuff like that. But I am not going to do a receivership. But if you do the other ones that require to give him notice, and if he doesn't show up and all that, I will uh, give you relief on that.
All right.
And then after you attempt that, I mean, we're just talking hypothetically now, but if you can't even find him, is receivership a proper remedy because it gives you so much power, so much more power to look for him? I don't know. I haven't thought about that. In the sense that you can approach a lending institution and get his bank account and all that. I haven't thought about that, but I haven't crossed that one yet.
All right. Well, I understand your owner's position, and we one possible option here, if you would consider it, maybe we leave this. We you not rule, you not deny this yet, and
Okay.
we'll see if we can get some discovery done, and then we'll come back and report on that and see if we can make some progress.
Okay. If you don't mind, if you can send me an email asking me not to do that,
Okay.
you don't have to put more detail, but I
Okay.
can sign off on it and I can file it in the file so that
Okay.
I will
Fine.
be I or whoever replaces me, if ever, you can refer to that request. That I mean, or submit an order. Well, no, I don't know why you put an order.
Just
And
asking you to leave it on your docket, basically.
yeah, you don't want to. Well, yes, they're always on. It's going to be in my docket forever. But as a post judgment, if you just send me the email, then you don't need to withdraw the order. You don't need to do anything except refer to this hearing where you're just asking the court to put any relief in abeyance. And then I'll sign off at the bottom of that email and I'll file it with the clerk.
That's fine. All right. Well, thank you for taking the time to explain all that to me. I appreciate
Yeah,
it. We
well,
will proceed accordingly.
yes, sir. Thank you.
All right. May I be excused?
May, sir. Thank you.
Thank you. Bye-bye.
Let me get the next one. Rafael Higareda versus iGlobal LLC. Who's here for that?
Good morning, Judge Bruce Gomez, Rafael
Okay.
Higareta.
I see Mr. Gomez here. And who
No.
else?
Mr. Carlos Quiñones for iGlobal LLC, Judge.
Okay. Quiñones, the lawyer, the
Yes.
defense lawyer. Is that correct?
Yes, yes,
Okay.
Judge. And I'm gonna move in on a motion for summary judgment.
Okay. And then, Mr. Gomez, you're here for whom? Your mic is off.
Can you hear me, Judge? Good morning.
Oh, I'm sorry. I thought I saw Mr. Gomez raise his hand. Oh, and then there's Bruce Gomez. Okay, go ahead.
So I'm Bruce Gomez, Your Honor. I represent the plaintiff, and then I have a response on the motion for summary judgment.
Okay. All right. Robert, if you can give me that paperwork, but in the meantime, if you can explain to me the background, the basis of the motion for summary judgment, and the basis for defending against it. Go ahead, Mr. Quiñones.
Thank you, Judge. So I represent iGlobal. Mr. Hugo Gomez is here. He's the one of the members of iGlobal.
Okay, hold on one second. Hold on one second. I assumed he was with no relation between Mr. Hugo Gomez and.
Oh, no,
Is that
no.
correct?
No, Judge.
Okay, thank you. Go ahead, sir.
Yes, and so he's here to essentially validate that Mr. Gomez through iGlobal, Mr. Hugo Gomez through iGlobal, has not received any payments on a mortgage, on a deed of trust transaction. So we're asking for summary judgment. We believe that it's proper now, as the plaintiff has failed to present any admissible evidence raising a genuine issue of material fact. It's not disputed that Mr. Igarreda,
Mhm.
he voluntarily executed a deed of trust, a note, a warranty deed, and the transaction was supported by valuable consideration. His claim of wrongful foreclosure is not substantiated. He hasn't shown that iGloba has failed to follow proper procedures under the code. In fact, the violations regarding the spouse's signature, or that it wasn't recorded, or the title company, something about the title company, all those are attempts, conclusionary attempts, and they're not supported by evidence. And so we're asking, because there's no valid claim for a breach of contract, which is really the issue, right? If there's no, we're saying there's no breach of contract if you're not paying your mortgage. And so we're asking today, Judge, to grant the motion to dismiss so that my client can receive his property back. The key point here is that Mr. Igarreta has not made any payments on this property for over, I believe, 18 months. And so we're here today to ask the court to grant the motion. Thank you.
Okay, Mr. Quinones, you're in El Paso, right?
Yes, I'm here.
And Mr. Gomez, you're in El Paso, right?
That is correct, Your Honor.
Okay. I guess if you just want to give me a very brief response, because what I want to do is I just want to hear about the background, get the paperwork that I need out of the file for that, and then I'm going to set you live.
Oh, okay.
And I'll give you a reason. These real estate cases, there's always another nuanced story behind them, and so they do require a little bit of attention in that manner. Plus, I'm going to require that your clients be there, or at least that Hugo Gomez is there, right? Okay, I want him there. So at the very least, but sir, if you could bring Mr. Quinones, if you could bring your client, because a lot of times on these real estate matters, there's another story behind the story, and I'd rather deal with them live. Thank you. I'd rather deal with them live, and then I've got all your paperwork, and I can read it, but part of it is legal briefing and citing the case and all. So I'm just trying to get a feel for what the story is behind the story. Were there any oral agreements, which I know they don't apply in real estate matters, but I'm going to try and do the right thing. I don't think that it's the law doesn't intend for someone to live someplace and not do something for 18 months. I am in full agreement with that concept. I mean, Mr. Gomez is here, and I have no idea what the basis is. But go ahead, Mr. Bruce Gomez, and brief me on a response to what he has to say.
Thank you, Judge. If I may please the court, this case lies on two issues, and simply two issues.
Okay.
Did IR Global follow the deed of trust? Did they give my client the right to cure under the property code 51.002D? And did they give my client the notice to accelerate under the property code 51.001?
Okay. I'm familiar with that. Okay. I mean, those are valid and all, but why no payments in 18 months? Even though you're in litigation, why has that been deprived? And then what preceded the 18 months that caused the foreclosure? So thank you for giving me an idea. That's exactly why I want to see this live, and I can eyeball them, not the lawyers, but I can have the parties there. Sometimes parties don't realize, oh yeah, I got me a lawyer and this happened or that didn't happen. And then my job is to try and figure out legally what is valid and what happened. So Robert Vasquez is my court coordinator. He will give you a hearing. He'll probably give you 2 or 3 dates. One of you send an email and CC everybody. He'll give you a choice of dates, and then we'll see you in my court live. And then, Robert, if you can set this in the afternoon, any of the afternoons that I have that I'm not gone from the office, or I'll meet these parties then in live. Okay, but that is an issue for me, Mr. Bruce Gomez, of why. I'm sorry, Hugo Gomez. Excuse me. You're the plaintiff, right?
He's a defendant, Your Honor, or
Oh.
he represents IR Global. So my client's not present here today, Your Honor. So
Oh, your client is a plaintiff.
yes, Your Honor.
Oh, I'm sorry. So I guess I'm direct. Okay. Well, why would you, as a plaintiff, be talking about an opportunity? Oh, because you're the debtor. I got it.
I filed this case to protect my client from losing his property, Judge, because he didn't get those 2 letters. If
Okay.
Mr. Jonas could provide those and he did send them certified, then we'll get rid of this case.
Well, y'all can talk on the side, so somebody doesn't run up any attorney's fees if you'd like. But that's not the only thing, though. I mean, the 18 months that are owed up to now, and then all they do is just modify the and say that his notice was the filing of the lawsuit and modify their pleadings and get a proper foreclosure. That's, I think, something that might be available. It would be better if you all settled it. It would be better, for example, Mr. Bruce Gomez, if your client can't afford to live in that house and all, that they cut their losses, but that's your business. I'm not telling you what to do. I'm just telling you that's why I want to meet with everybody live to find out what's going on. And the other thing is this. The law set up because nobody likes to have money owed, rightful money owed. Now, I've had another case where, yes, that happened, but they went back to a history of, 12 years relying on something, and somebody saying that it was a purchase contract, even though it was, it's that kind of thing that occurs among parties that aren't, that lack maybe a sophistication, or maybe they have too much sophistication, and we end up with this. That's why I need your life. But if you all were to settle this, you're also talking about either party, your client saving on attorney's fees or whatever, because when I take that into account, I will take into account a claim for attorney's fees. If we had to do this procedure just because somebody hadn't paid or whatever, I'm going to take that into account as well. Or if it was wrongful, I'm going to take that into account. But I want a live hearing, okay?
Sounds like a plan, Judge. Thank you
Oh,
for your time.
and incidentally, have you all been to mediation?
Not yet, Judge.
Let me ask you this, Mr. Quiñones. Would you like to go to mediation first and then sit with me?
I think we probably need a setting first, and then.
Okay, all right, I'll do that.
But in the meantime, me and Mr. Gomez will talk. Mr. Bruce Gomez will talk.
I have an offer for Mr. Quiñones, Judge, that I think it'll get rid of the entire case.
That'd be fantastic. Okay, but so I guess I'm gonna wait until you all call Robert for a setting, but I want a live setting next time.
Yes,
Unless
sir.
you have an agreement, and then we can do the Zoom if I'm needed. And if not, you can submit orders, and usually when there are orders by agreement, they get signed. All right?
Sounds like a plan. Thank you, Judge, for your time.
Thank you,
Okay.
Judge.
Thank you, Mr. Quiñones,
Thank you.
as well. Okay, who's next? I have Rena Dieda versus Hawkins Self Storage LL and Easy Storage. Anybody here for that?
Judge, I won't sit at 10 o'clock.
Okay, thanks. That's in 30 minutes. All right. And then let me see. That's it for right now then. Thank you very much. And we'll resume.